A. The Supreme Court's separation of powers balancing test applies in this context. A congressionally imposed limitation on presidential action is assessed to determine the extent to which it prevents the executive branch from accomplishing its constitutionally assigned functions, and if the potential for disruption is present, whether that impact is justified by an overriding need to promote objectives within the constitutional authority of Congress. Administrator of General Services 433 U.S. F 443, C. Nixon v. Fitzgerald 457 U.S. 731, 753 through 754, 1982, United States v. Nixon 418 U.S. 683, 706 through 707, 1974. That balancing test applies to a congressional regulation of presidential power through the obstruction of justice laws. When an Article II power has not been explicitly assigned by the text of the Constitution to be within the sole province of the President, but rather was thought to be encompassed within the general grant to the President of the executive power, the Court has balanced competing constitutional considerations. Public Citizen 491 U.S. at 484. Kennedy J. concurring in the judgment, rejoined by Rehnquist C.J. and O'Connor J. As Justice Kennedy noted in Public Citizen, the Court has applied a balancing test to restrictions on the President's power to remove executive officers, a power that is not conferred by any explicit provision in the text of the Constitution, as is the appointment of power, but rather is inferred to be a necessary part of the grant of the executive power. Id citing Morrison v. Olson 487 U.S. 654, 694, 1988, and Myers v. United States 272 U.S. 52, 115 through 116, 1926. Consistent with that statement, Morrison sustained a good clause limitation on the removal of an inferior officer with defined prosecutorial responsibilities after determining that the limitation did not impermissibly undermine the President's ability to perform his Article II functions. 487 U.S. at 691, 690 through 693, 695 through 696. The Court has also evaluated other general executive power claims through a balancing test. For example, the Court evaluated the President's claim of an absolute privilege for presidential communications about his official acts by balancing that interest against the judicial branch's need for evidence in a criminal case. United States v. Wilson v. Nixon supra, recognizing a qualified constitutional privilege for presidential communications on official matters. The Court has also upheld a law that provided for archival access to presidential records despite a claim of absolute presidential privilege over these records. Administrator of General Services 433 U.S. at 443 through 445, 451 through 455. The analysis in those cases supports applying a balancing test to assess the constitutionality of applying the obstruction of justice statutes to presidential exercises of executive power. Only in a few instances has the Court applied a different framework. When the President's power is both exclusive and conclusive on the issue, Congress is precluded from regulating its exercise. Zedovsky v. Carey, 135 SCT 2076, 2084, 2015. In Zedovsky, for example, the Court followed Justice Jackson's familiar tripartite framework. In Youngstown, Sheet and Tube Co. v. Sawyer, 343 U.S. 579, 635 through 638, Jackson J. concurring and held that the President's authority to recognize foreign nations is exclusive. Id at 2083, 2094. See also Public Citizen 491 U.S. at 485 through 486. Kennedy J. concurring in the judgment, citing the power to grant pardons under U.S. Constitution Article 2, Section 2, Clause 1, and the presentment clauses for legislation, U.S. Constitution Article 1, Section 7, Clauses 2 and 3, as examples of exclusive presidential powers by virtue of constitutional text. But even when a power is exclusive, Congress's powers and its central role in making laws give it substantial authority regarding many of the policy determinations that precede and follow the President's Act. Zidovsky 135 SCT at 2087. For example, although the President's power to grant pardons is exclusive and not subject to congressional regulation, see United States v. Klein, 80 U.S. 13 Wall 128, 147 through 148, 1872. Congress has the authority to prohibit the corrupt use of anything of value to influence the testimony of another person in a judicial, congressional, or agency proceeding. 18 U.S.C. Section 201b3, which would include the offer or promise of a pardon to induce a person to testify falsely or not to testify at all. The offer of a pardon would precede the act of pardoning and thus be within Congress's power to regulate, even if the pardon itself is not. Just as the Speech or Debate Clause, U.S. Constitution, Article 1, Section 6, Clause 1, absolutely protects legislative acts but not a legislator's taking or agreeing to take money for a promise to act in a certain way, for it is taking the bribe, not the performance of the illicit compact, that is a criminal act. United States v. Brewster, 408 U.S. 501, 526, 1972, emphasis omitted. The promise of a pardon to corruptly influence testimony would not be a constitutionally criminalized act, immunized act. The application of obstruction statutes to such promises, therefore, would raise no serious separation of powers issue. The effect of the effect of obstruction of justice statutes on the President's capacity to perform his Article II responsibilities is limited. Under the Supreme Court's balancing test for analyzing separation of powers issues, the first task is to assess the degree to which applying obstruction of justice statutes to presidential actions affects the President's ability to carry out his Article II responsibilities. Administrator of General Services 433 U.S. at 443. As discussed above, applying obstruction of justice statutes to presidential conduct that does not involve the President's conduct of office, such as influencing the testimony of a witness, is constitutionally unproblematic. The President has no more right than other citizens to impede official proceedings by corruptly influencing witness testimony. The conduct would be equally improper whether effectuated through direct efforts to produce false testimony or suppress the truth, or through the actual, threatened, or promised use of official powers to achieve the same result. The President's action in curtailing criminal investigations or prosecutions, or discharging law enforcement officials raises different questions. Each type of action involves the exercise of executive discretion in furtherance of the President's duty to take care that the laws be faithfully executed. U.S. Constitution, Article 2, Section 3. Congress may not supplant the President's exercise of executive power to supervise prosecutions or to remove officers who occupy law enforcement positions. See Boucher v. Sinar, 478 U.S. 714, 726 through 727, 1986. Congress cannot reserve for itself the power of removal of an officer charged with the execution of the laws, except by impeachment, because the structure of the Constitution does not permit Congress to execute the laws. This kind of congressional control over the execution of laws is constitutionally impermissible. Yet the obstruction of justice statutes do not aggrandize power in Congress or usurp executive authority. Instead, they impose a discrete limitation on conduct only when it is taken with the corrupt intent to obstruct justice. The obstruction statutes thus would restrict presidential action only by prohibiting the President from acting to obstruct official proceedings for the improper purpose of protecting his own interests. See Volume 2, Section 3A3 Supra. The direct effect of the President's freedom of action would correspondingly be a limited one. The preclusion of corrupt official action is not a major intrusion on Article II powers. For example, the proper supervision of criminal law does not demand freedom for the president to act with the intention of shielding himself from criminal punishment, avoiding financial liability, or preventing personal embarrassment. To the contrary, a statute that prohibits a fictional action undertaken for such personal purposes furthers rather than hinders the impartial and even-handed administration of a law. And the Constitution does not mandate that the President have unfettered authority to direct investigations or prosecutions with no limits whatsoever in order to carry out his Article 2 functions. See Heckler v. Cheney, 470 U.S. 821, 833, 1985. Congress may limit an agency's exercise of enforcement power if it wishes, either by setting substantive priorities or by otherwise circumscribing an agency's power to discriminate among issues or cases it will pursue. United States v. Nixon, 418 U.S. at 707. To read the Article 2 powers of the President as providing an absolute privilege to withhold confidential communication from a criminal trial would upset the constitutional balance of a workable government and gravely impair the role of the courts under Article 3. Nor must the President have unfettered authority to remove all executive branch officials involved in the execution of the laws. The Constitution establishes that Congress has legislative authority to structure the executive branch by authorizing Congress to create executive departments and officer positions and to specify how inferior officers are appointed, e.g., U.S. Constitution, Article 1, Section 8, Clause 18, Necessary and Proper Clause, Article 2, Section 2, Clause 1, Opinions Clause, Article 2, Section 2, Clause 2, Appointments Clause. See Free Enterprise Fund, 561 U.S. at 499. While the President's removal power is an important means of ensuring that officers faithfully execute the law, Congress has a recognized authority to place certain limits on its removal. Id at 493 through 495. The President's removal powers are at their zenith with respect to principal officers, that is, officers who must be appointed by the President and who report to him directly. See Free Enterprise Fund, 561 U.S. at 493, 500. The President's exclusive and illimitable power of removal of those principal officers furthers the President's ability to ensure that the laws are faithfully executed. Id at 493, 498, internal quotation mark submitted. Myers 272 U.S. at 627. Thus, there are some purely executive officials who must be removable by the President at will if he is able to accomplish his constitutional role. Morrison 487 U.S. at 691, Myers 272 U.S. at 134. The President's cabinet officers must do his will. In the moment that he loses confidence in the intelligence, ability, judgment, or loyalty of any one of them, he must have the power to remove him without delay. C.F. Humphreys, Executor v. United States, 295 U.S. 602, 1935. Congress has the power to create independent agencies headed by principal officers, removable only for good cause. In light of those constitutional precedents, it may be that the obstruction statutes could not be constitutionally applied to limit the removal of a cabinet officer such as the Attorney General. See 5 U.S.C. Section 101, 28 U.S.C. Section 503. In that context, at least absent circumstances showing that the President was clearly attempting to thwart accountability for personal conduct while evading ordinary political checks and balances, even the highly limited